us today. Before we get started, if you find this helpful, please do take a second to like and subscribe. It really helps us keep bringing you these analyses. Okay, so today we're looking at something, well, pretty fundamental. It's about how we define who's an employee and who's an independent contractor. Yeah, it sounds maybe a bit technical, but the difference. It has huge real-world consequences for pay, for benefits, for how companies, structure things. And we're going to focus specifically on a new proposal, House Resolution 1319. It's aiming to redraw that line, basically, under some really key labor laws. So our job today is to unpack what this resolution actually says, what changes it's proposing, and why this whole employee versus contractor thing matters so much.
Absolutely. It's a distinction that echoes through almost every industry. Think about the gig economy, tech, traditional jobs. How someone's classified affects their rights, their protections. So yeah, clarifying these definitions, it could have a really significant impact on work arrangements moving forward. It's about bringing some clarity, hopefully, to a pretty complex area.
Okay, let's jump right in then. House Resolution 1319. It was introduced in the House back on February 13th, 2025. Mr. Healy from California brought it forward, along with Mr. Rutherford, Mr. Milinar, Mr. Messmer, and Mr. Ogles. And the bill's stated aim is pretty direct: to amend the Fair Labor Standards Act of 1938 and the National Labor Relations Act to clarify the standard for determining whether an individual is an employee and for other purposes.
Right, and focusing on those two acts, the FLSA and the NLRA, that's really key. Why those two? Well, the Fair Labor Standards Act, the FLSA, that's your bedrock for things like minimum wage, overtime pay.
Basic working conditions, hours.
Exactly. It covers the fundamentals of pay and hours for so many workers. Then you have the National Labor Relations Act, the NLRA. That one's all about collective bargaining. It protects the right to organize, form unions, act together for mutual aid or protection.
So changing definitions here.
It means potentially changing who gets those FLSA wage protections and who gets those NLRA organizing rights. That's why tweaking definitions in these specific laws is such a big deal. It affects core aspects of work for millions.
Got it. Okay, so let's get into the nitty-gritty of this resolution. Section 1 tackles the Fair Labor Standards Act. It's amending Section 3E, which is about definitions. And it's proposing a new way to define an independent contractor. So what's the proposed test?
It really boils down to two main criteria laid out in the proposed Section 3E2. So an individual is an independent contractor if, first, the hiring party does not exercise significant control over the details of the way the work is performed. And it adds, without regard to any control the other person may exercise over the final result of the work performed.
Okay, details of the way the work is performed versus the final result. Can you give an example of that?
Sure. Think about hiring a freelance writer. You, as the client, you definitely control the final result. You specify the topic, the length, the tone, maybe the key points to include.
Right. What you need delivered.
Exactly. But under this rule, you wouldn't be dictating how they research, what software they use to write, their working hours, as long as they deliver that final article meeting your specs. That distinction is crucial here. Control over the outcome, not the process.
Okay, that clarifies the control aspect. What's the second criterion?
The second one, it's about entrepreneurship. It says while doing the work, the individual has the opportunities and risks inherent with entrepreneurship, such as the discretion to exercise managerial skill, business acumen, or professional judgment.
So they need to be acting like a business, essentially.
Pretty much. Are they making decisions that affect their profit or loss? Are they investing in their own tools? Marketing themselves? Taking on financial risk? It's looking at whether they genuinely operate with the independence and, the potential upsides and downsides of running their own show.
Okay, so control over the how and the presence of entrepreneurial opportunity and risk. That's the core test for being an independent contractor under this proposal. But then, and this is really interesting, it also lists things that cannot be used to say someone is an employee.
That's right, Section 3(2)(b). This part seems designed to head off common arguments and classification disputes. It lists 4 specific factors that may not be used to classify someone as an employee.
What are they?
Okay, first, requiring compliance with legal or regulatory requirements.
Meaning?
So if you hire an independent trucker and you require them to follow, say, Department of Transportation safety regulations.
Which they have to follow anyway.
Exactly. That requirement alone doesn't make them your employee under this bill. It's just following the law.
Makes sense. What's next?
Second, requiring compliance with health and safety standards, even if they're stricter than the usual ones.
Ah, like in a specialized setting.
Right. Maybe a lab has very specific safety protocols for handling certain materials. Requiring an independent consultant working there to follow those extra strict protocols wouldn't by itself make them an employee. It's about necessary precautions.
Okay. Third factor.
Requiring the individual to carry insurance, any kind of insurance.
So if a company hires a contractor and says, you need liability insurance for this project.
That requirement wouldn't count towards making them an employee. It's seen as a standard business practice for independent contractors to manage their own risk.
And the last one.
Fourth, requiring the individual to meet contractually agreed upon performance standards, like deadlines.
Oh, that's a big one. So you can set a deadline for a contractor.
Or specify quality standards for the deliverable. And according to this bill, those contractual requirements wouldn't on their own make that person an employee. It separates project requirements from employment control.
So putting these prohibited factors together, it seems like a company could require a contractor to follow laws, meet safety rules, carry insurance, and hit deadlines, and none of that automatically points towards an employment relationship.
That's the implication, yes. It carves out these specific, common business requirements from the control analysis. The focus stays on that core test. Significant control over the manner of work and the entrepreneurial opportunity aspect.
It feels like that could offer businesses, well, a clearer path for working with contractors without constantly worrying about tripping into an employment classification just by setting basic project parameters or safety rules.
Potentially, yes. The aim appears to be providing more certainty. For businesses, especially those using flexible workforces like, say, tech platforms or project-based industries, knowing they can enforce safety, legal compliance, and deadlines without automatically creating an employer-employee relationship could be significant.
It reduces ambiguity.
It tries to, yes. It draws lines around things like ensuring quality or safety, framing them as standard contract terms rather than indicators of employment control. This might make businesses feel more comfortable engaging contractors for specific needs, knowing the ground rules are potentially clearer.
Now, this resolution isn't just tinkering with the Fair Labor Standards Act. It also loops in the National Labor Relations Act, the NLRA. What's the connection there?
Right. Section 2 of the bill tackles the NLRA. And it does something quite straightforward, actually. It amends Section 2.3 of the NLRA, which defines employee, and it says the exact same standard, the 2 criteria for contractor status, and the 4 prohibitive factors we just discussed for the FLSA, quote, shall be used for the NLRA too.
Ah, so one definition fits all for both laws.
Exactly. A unified standard.
What's the significance of that? Having the same definition for both the FLSA and the NLRA?
It's quite significant. Remember, the NLRA governs rights like forming unions and collective bargaining. These rights are generally for employees, not independent contractors. So if this bill passes, the same test that determines if you get minimum wage and overtime under FLSA would also determine if you have the right to unionize under NLRA.
One classification, covering both wage hour and labor relations rights.
Precisely. It aims for consistency, avoiding situations where someone might be considered an employee under one law but not the other, which can happen now with different tests sometimes being used. But it also means that classification decision becomes even more critical. If you're deemed an independent contractor under this unified standard, you wouldn't have NLRA protections for organizing. This could really shape labor dynamics in industries with lots of contractor-like roles.
Okay, pulling this all together, what does this mean for you listening? Whether you're running a business, working as a contractor now, or maybe thinking about gig work down the line, how could these changes actually, play out?
Well, fundamentally, this is one approach, a legislative proposal to bring clarity to a really debated area. If it were to become law, you'd have a clearer, federally defined line. For individuals, knowing these specific proposed criteria, the control test, the entrepreneurial opportunity part, and crucially, what doesn't count towards being an employee, helps you understand how your work arrangement might be viewed under federal law. Would you fall under employee protections or operate as an independent business? For businesses, it potentially offers a more predictable framework, less gray area, maybe, around setting standards for quality, safety, or deadlines when working with contractors. But it really emphasizes that distinction. If someone is classified as an independent contractor under this test, they are truly operating as a separate business entity, with all the freedoms and, importantly, all the risks that entails. It's not just a label change. It affects benefits, taxes, legal rights, everything.
So to recap the main points, House Resolution 1319 puts forward a specific 2-part test focusing on control and entrepreneurial opportunity to define independent contractors. And it clearly states that things like legal compliance, safety rules, insurance requirements, and deadlines cannot be the deciding factors for employee status. And this single definition would apply across both the Fair Labor Standards Act and the National Labor Relations Act.
That's the core of it. And it leaves us with a final thought, perhaps for you to consider. If we have a single clear definition like this across these two major federal labor laws, how might that reshape the future of work? Think about the kinds of jobs available, the balance of flexibility and security, and the overall relationship between workers and companies in the years ahead. What kind of landscape might emerge?
Definitely something to think about. Thank you for walking us through that proposal, and thank you all for tuning in today. We hope this look at House Resolution 1319 gave you some valuable insights into these proposed changes and what they might mean. Join us next time.